Thank you. That was Himanshu Mali from MongoDB. You could head to their stalls, buy the virtual stalls, and there are some cool giveaways there. You could also fill in feedback forms for some great prizes. Now, privacy has had the spotlight shone brightly on it, and the discussions around privacy have reached an all time crescendo. Now, with the cloud and multiple clouds, this aspect needs to be considered and given focused attention. Now, how do you navigate data privacy in the cloud era and address issues around data sovereignty and localization? Well, to answer that, we have Shivangi Nadkarni, co-founder and CEO of Arrka Consulting, joining us in this conversation with Rahul Nirmani, the co-founder and editor at Greyhead Media. Over to you, Rahul.
Hey, thank you, Ashwin, and welcome once again to the second edition of Dynamic CIO India Cloud Summit. We are up here for a very interesting session now, which talks about navigating data privacy in the cloud era and how to address the issues of data sovereignty and localization. I mean, these issues have come up even more vociferously and very prominently in the past few years. The bill, India Data Protection Bill, is right there to be introduced in this session of Parliament. I guess so. That's been the intent. It has been listed as the activities. So we hope that that is tabled and very soon it becomes a reality. Now, before we begin this conversation, I would like to give a small introduction to the whole session, the topic, introduce our guest speaker, who really needs no introduction, but still I will. So the era of cloud is here, and more so after recent disruptions that stirred the whole world very dramatically. What emerged from it was the game-changing innovations using cloud computing that allowed flexibility, elasticity, and agility to most organizations that were feeling the heat and were challenged by severely paralyzed world. We all know that cloud-based services offer unparalleled scalability and flexibility. The business benefits are so compelling that adoption is likely to surge at a very rapid pace across all industries and sectors. Also, organizations that face constraints like limited budgets and increasing growth demands. I think cloud computing provides an immediate relief on many counts, including reduction in cost, reduction in operational cost, reduction in capital expenditure, increased flexibility, and improved IT capability. Now, while the organizations are at liberty to choose specific cloud instances where they want to host or locate their applications and infrastructure, however, the challenges still remain in the face of growing privacy regulations and data protection concerns. I would say that though slowly, but we are getting clarity on the laws and regulations about whom the accountability of data privacy lies with. A lot of initial inhibitions have already gone, and with the time, there will be more clarity as both regulators and cloud service providers work together to iron out these challenges. But it is also true that CSPs are often not ready to fully disclose the security measures they use to protect information or how they process the data, which causes some kind of problems in the light of proliferation and magnitude of recent privacy breaches, which have resulted in class action lawsuits or reputational damages for the users of the cloud ecosystems. It is therefore not surprising that organizations which want to move to the next generation of outsourced cloud services are genuinely concerned about the privacy and data protection issues in the cloud. So we need to understand that security of data is not a binary responsibility. Both the organization which is using the cloud as well as the organization which is providing the cloud services, they both have a role to play. The current challenge is that most large cloud service providers do not really take up or own the accountability and consequent liabilities for their spheres of responsibilities. If we read through the fine prints of contract, we would realize that often the organization is left to take up the downsides. Now, in this case, how should the CIOs and CISOs understand and comply with data protection and privacy laws? How should they understand, how to deal with the CSPs when it comes to protection of data? Um, with this as a very short background, I would like to welcome Shivangi Nadkarni, co-founder and CEO of Arrka Consulting. Shivangi is one of India's most renowned and leading privacy and data protection experts that I have personally known. And of course, the whole community knows her very well. So welcome to the India Cloud Summit, Shivangi. How are you doing?
Thank you so much, Rahul. Thank you for inviting me and giving that very warm and generous introduction, I must say. Thank you. I'm very well.
No, great. It's always pleasure talking to you. I must say that in all these years that I have known you personally, immense gain in my knowledge on the data protection and privacy issues that come. That increase every year as the time passes. So we need to start this conversation with some key issues of accountability, liabilities, and responsibilities, along with a clear articulation of who does what. So if you can give a slightly elaborate answer to that, that will set the tone for this whole session.
Okay, great. So, you brought up in your introduction, you have talked about, or, you have the cloud service providers or the CSPs, you have organizations, and the obfuscation of lines of responsibilities between the two when it comes to cybersecurity as well as data privacy, right? So let's look at the cybersecurity part of things first. If you look at implementing security overall, whether it's cybersecurity and overall security, it is always a series of measures that need to be undertaken, right? And those series of measures have to spread across all the players in the ecosystem. So when I say an organization, it is not just the organization, it's vendors and other stakeholders as well, in which the CSP is one of the key stakeholders. Right now, that spread of what responsibility lies in terms of what measures, first of all, to take and how they need to then pan out has to be clearly articulated. Many a time, and when you say CSPs, it's not just one monolithic sort of offering that comes from a CSP. Right? There are versions, there are flavors, there are layers available, and it depends on what really an organization subscribes to, and therefore in that subscription package, so to say, how much of security is built in finally. Right? And then the organization needs to take that overall view, understand what is expected of it, understand what it wants the CSP to do, and what is therefore the responsibility of the CSP, and look at it as one monolithic, one continuous sort of frame. I am not sure how much of this is being done. So first of all, I think in terms of organizational security measures, there has to be a clear articulation of what are the expected measures that the CSPs require to take, and how, depending on the solution that the organization has sort of subscribed to. Within those frames, how much of it is the CSP really taking up, and how much of it is it not taking up, right? So there are some things that a CSP, despite it not being in the organization's control, may not take. In this, the organization will have to figure out controls at its end as a compensatory sort of, compensatory controls to make up for what the service provider is probably not providing, right? Now, having said all that and assuming all of that is implemented and is in place, then how do you make sure that it is actually working? Therefore, mechanisms of oversight, governance, audit, all of those come into picture. And finally, it is the fine print in the contract as well, as you pointed out, right? Contractually, how much of it is being taken care of? Because bottom line is accountability. It's not as though the CSP is expected to lay out all the details of what it does for security, but there is certainly an expectation from any of its clients that it will take basic measures and will remain accountable for those measures. So I have gone through several contracts where, when it comes to accountability and taking on the liability, usually it is not being undertaken, right? And given the fact that usually CSPs are very large organizations, the client, the organization who's the buyer, is not in a position of even dictating, forget the word actually dictating, asking for certain things, which is why that portion remains unaddressed. And that unaddressed portion of accountability and therefore the associated liabilities is what then becomes a bone of contention. That's my view of the overall sort of problem associated with security and the cloud. I don't know. I mean, you've seen.
No, excellent. I think the statement that we both share, that security of data is not a binary responsibility, and both user organization as well as the CSPs have a role to play. Apart from that, you also said that there are other stakeholders. It's not just the CSP alone. There are other stakeholders. However, as you rightly mentioned, that it all depends on how you draft the contract and how the bottom line of accountability is set. But in many cases, you also mentioned that in many cases, the user organization is not even aware of how to negotiate this contract so that these concerns are well taken care of and the accountability is fixed. So where do the CIOs and CISOs go wrong? Is there an internal is there a lack of coordination internally which leads to this problem, or what is it? I mean, how can this be overcome?
Okay, so there can be different layers. Okay, so I'm not saying anybody is going wrong. Wrong is a wrong word to use, so to say, right? So maybe there could be a situation where even the CISO, whom the CIO relies on, maybe the CISO has not taken that overall view of, maybe just treating the CSP like yet another vendor, and maybe a high risk vendor, but still treating it like a vendor and therefore not a part of the core organization, vis-a-vis treating the CSP like a part of a continuum. So there could be instances like that, maybe more out of maybe not deliberately, it may have happened as a gap, right? But I'm assuming that is not the case with most people. And then it comes down to what is really the subscription that is taken, which is, I feel, it should be a joint decision between the CIO and the CISO, assuming the CIO is the one who's availing the service finally, to see whether the necessary sort of security measures that is expected from an external person has been taken into account as part of the contract. I feel that it is not so much, it may be a little bit, so the next layer may be a bit of lack of awareness, maybe in some circles. There can be also, and remember, the contract is only an instrument of control, right? That's the mechanism by which you, articulate what every party is expected to do and so on. Many a time there is a legal team involved in this, and many a time the legal team is not equipped to look at some of these technical details and nuances which have to come from the CIO and CISO. I am not sure how many people really sit together and look at this as a problem that needs to be sorted together. Larger organizations sometimes tend to act in silos, so that could be a challenge. Now, having transcended that and sat together with the legal team, there then has to be a view of looking at what is expected out of the contract, which comes out of what is expected out of the CSP. From what I have observed, it is sometimes, the CSP is a large MNC many times, and the attitude, and this is anecdotal, I may be completely wrong, but this is what I have heard from several people, is that the attitude is take it or leave it. The contract part is there's virtually nil flexibility in terms of some of these conditions that come as part of the contract. And many times the buyer organization is not large enough to push back, right? I've seen some in a few cases where the buyer organization push back and exert some amount of control, but most of the time it is like a you know what I call is a standard templatized contract which you sign off. And when you sign off, I've seen many of these templatized contracts where the CSP essentially end of the day says, bottom line, I will do my best, but it is best effort, and I am not taking liabilities. That's the general tone that comes out. Again, as I said, anecdotal, but maybe that is the real reality in the industry today.
No, so you're right. I mean, it is anecdotal, and there may be. I mean, you are right. So, in many cases, especially in cases, and I'm intrigued to know about it, especially in cases where there's a lot of use of shadow IT, where different business domain, I mean, different business departments start using cloud without too much of involvement of legal and IT teams and security teams. I think this could be a major problem in such cases, if I'm not wrong.
Oh, absolutely. And in fact, this shadow IT, I mean, it gives me and, my clients with whom we roll out privacy programs, the vendors of shadow IT don't even come under the purview of, forget the CISO, even the CIO, right? And people are signing contracts left, right, and center because it's not perceived to be anything to do with IT, right? And when we are looking at it from privacy alone, right? We're leaving the security portions out, but looking at the privacy part of things, a lot of this has direct impact, and we've seen so many incidents which have bubbled up, and suddenly like I can narrate one incident where a financial institution had one of its business teams sign up with a vendor who was located overseas, and there was personal data being sent to the vendor, and the prospective clients had to go, so consumers had to go and actually log on to that vendor's website, and you give out a whole bunch of personal data, including sign in via Google, sign in via Facebook kind of options. And somebody had brought it out in the media, and there was a huge incident around it. And only when it became an incident that everybody woke up and said, hey, who signed this, right? And how did this get signed? And those implications are hard. So of course, in this case, then there was a huge program that made sure something like this doesn't happen. But why should every organization learn its lesson on its own? Right? So you've opened a can of worms by talking about shadow IT, but I think it's an opportunity to say that, hey, that's a huge problem that you need to worry about today. You're on mute, Rahul.
Sorry. I think it was a very impromptu question to you. However, I realized that this also leads to a big point, that in the light of current situation where we are, I mean, there were data protection laws earlier as well. However, in the situation where we have a full-fledged data protection law coming in, how should an organization, forget about the personas, CIO, CISO, risk officer, legal teams, marketing officers, and whoever deals with the data of people, I mean, private data, how do they need to buckle up to ensure that they are, before signing any contract with a cloud provider, they are reading the between the lines, they are reading the fine print, and also they have some kind of pushback now because the consequences of this will be grave.
Oh yeah, that's a very detailed kind of question. Actually, the answer is long-winded, but I would say that so when you're looking at signing up a contract, or rather, I would say I would put it a little more high level. When you're getting into a relationship with another vendor, where you then have to look at all the risks associated with that vendor. And of course, to be able to mitigate those risks, start with putting some of them in the contract and then have other supplementary controls in place, like, audits, checking from time to time, building evidences, and so on. So we're not even getting into that. Now, if you look at data protection laws around the world, right, some commonalities are evident, and that's the way the world is going. And we've studied about close to 30 laws, and keep looking at even the drafts, so I can say this with a certain kind of conviction, right? So data localization slash sovereignty slash, there are numerous terms used for this, but that as a phenomena is there to stay for a while. Okay, so every country is putting norms in place to have certain kind of data and certain kind of constraints in terms of cross-border or trans-border data flows. And therefore, that is something which every organization has to live with, especially if they're if they're operating in a multinational scenario. Okay. And therefore, that is one of the major concerns, and we will look into that. Point number two is about the whole security of data that we just talked about, right? How do you ensure security? And what is called increasingly in the world of both cybersecurity and privacy is called accountability and demonstrability of that accountability. Which is, they're actually two slightly different things, which is, one is that you remain accountable, and part B to that is you're able to demonstrate that you have remained accountable, which is done via, different kinds of evidences, logs, etc. So that is something which everybody has to actively sort of start playing a role to make sure that whatever measures they implement, they build in that demonstrability component as well. So that you're not scrambling if there is when there is an incident rather. So there is the whole security aspect. Then there is, in the world of privacy, you have two types of organizations. You have what are known as data controllers, who are the main ones, and then you have processors, right? All CSPs, for example, would come under the processor category, no matter how detailed and how elaborate a service they provide. Now, in this case, a processor, most laws are again evolving to recognize processors specifically, right? So it began with GDPR, because earlier you had that only spoke to the controller, completely put all the liabilities on the controller, and remained opaque, saying, hey, you want to outsource, you want to have processors, it's your problem. We are not recognizing them. Whereas the GDPR came along and started recognizing processors, saying that, it's okay, we are putting, responsibility on the, controller, but hey, Mr. Processor, you are equally responsible. And therefore, there are liabilities and all of that. So if you see, the Indian ITS industry for the last couple of years has been very actively implementing a lot of these security and privacy measures, simply because they are processors, right? And similarly, the CSPs. So therefore, as processors, there are many things from a privacy perspective as well that they need to look at, right? One major thing, and this is again anecdotal, but I have come across this in some of the contracts that I've seen over the last few years, is there is this concept of who owns the data, right?
Yeah.
Now, some laws, of course, laws like the GDPR or what the India Data Protection Bill talks about, is very clearly the final owner, and I'm using this in quotes because the concept of ownership from a legal basis is something else, and neither you nor I are lawyers, but the principle, right? That's why the Data Protection Bill of India calls individuals like you and me principals, because finally it's about our data.
Right.
But this concept of finally the controller, is the custodian, right, of the data, and that data then gets passed on to the processors.
Yeah.
Now, I've seen contracts where the CSP stakes claim over all the data that is in its custody, which is completely in contradiction to many of the laws. So that is something which every organization, however small, has to pay attention to. I'm sure by now contracts have evolved, but if there are any remnants of this, please be very careful, because accountability is yours. So therefore, if you are accountable, you cannot let a contract loosely say that, okay, whatever data is hosted, you have rights to that data, essentially, rights to view the data or whatever. So while you better keep it secure, I'm not giving you the rights, Mr. CSP, to take a look at that data and do some further analysis and processing on it.
Absolutely.
Yeah. So if you see, forget just the CSPs, if you see a lot of platform solution providers today, they use the data, and again with no malicious intent. It is done to, let's say, for example, improve the quality of the platform, improve the quality of the product offered, or to do an analysis of the kind of traffic or whatever. I mean, there are n number of reasons, but that data is being used by many of these platform solution companies. Now, that is a complete violation of privacy laws, right? So those are some of the things that an organization needs to pay attention to.
No, I understand, and I think this is not an easy problem to handle because as you very rightly mentioned in the beginning, that it also requires a lot of maturity at the organization's end to understand the difference between the data controllers, between the data processors, the data ownership. Whole host of things need to be understood before. And then there is an urgency to subscribe to the services, the cloud services. Long gestation periods need to be shortened to make use of that infrastructure for the purpose for which you are signing the contract. Okay. Lastly, while we have discussed a lot of problems and challenges, it might sound that we are talking about cloud in the light that it is very prohibitive in terms of anything that you want to do using the cloud infrastructure. However, the proliferation of cloud also provides a tremendous opportunity to organizations in today's time and context. So how do the organizations carefully chart a plan, keeping in mind the issues of data privacy and data sovereignty that you have discussed all this while? Just in a nutshell.
Okay, so I've always maintained that the cloud opportunity is very, very powerful, especially for startups and smaller organizations, not just in India, globally. It actually is the mechanism by which it enables organizations to cater to privacy laws, right? So, for example, data sovereignty. I'm a company, let's say, based out of India. I cater to consumers in 40 different countries around the world. And every country is going to come up with some amount of sovereignty, localization, etc. I can sit in India and re-architect my platform, and people are doing it, by the way, in such a way that data doesn't leave the geography it is, sort of being processed. And I can do it sitting in India because I have the flexibility and an opportunity from my cloud service providers to host instances in different locations without really having to go there and set up an office or find a local service provider and so on and so forth, which a few years ago was not even an option, right? So look at the opportunity it opens up for organizations to be able to actually cater to address all these data sovereignty requirements without really having to spend humongous amounts of resources doing that. So, so while you may look at all the fine print and the contracts and make sure all your bases are covered, do that and leverage that huge responsibility. I feel that's really very powerful today to folks like us.
No, great. I think it's a very serious conversation, and unlike something which is, at some point IT was commoditized. Today, cloud is commoditized, and therefore the usage will certainly go high. However, the crux of this whole session is that before you move on to before you move your critical workloads or any kind of workload which has implications on business or on its reputation, I think it is very important to understand the nuances of moving your data onto the cloud, especially with the data which has serious ramifications if it leaks or if it is breached. So thank you very much, Shivangi. I hope we had a little more time to involve you in this conversation. However, as I said in the beginning, whenever we talk to you, some new things come out, and I hope our listeners, our delegates who are joining this conference have gained a lot of insights from this. Thank you very much for your contribution. Over to you, Ashwin.